Today we're going to talk about parenting mediation, and I'll go through in a little bit of detail about it. If you are current practitioners, you might have some different approaches, and feel free to contribute and share your thoughts as well. So what I'm going to be talking about is the process that we teach at Mediation Institute. So before I proceed any further, though, I'd like to acknowledge Aboriginal and Torres Strait Islander people as the traditional custodians of Australia, and pay respects to elders past, present and our emerging leaders. I come to you today from the lands of the Gunai Kurnai people in southeast Victoria, and feel free to the chat to introduce yourself and where you are. I'm probably not going to be able to see if you share what you'd like to get out of the presentation today, but if you do have any particular things that you're wanting to know, please feel free to share those in the chat as well, and we'll try and get to that. You can also use the hands up to get my attention if need to, or just turn on your phone and say, hey, Joe, before you move on, feel free to do that as well. So I'm Joanne Law, Director of Mediation Institute. I'm a family dispute resolution practitioner and co-founder of Interact Support, which is a not-for-profit where I do my mediations, usually with a student or intern. What I wanted to go through today is what's our goal when facilitating parenting mediation, a little bit about the process, some of the tools that we use. I'll talk through in a little bit more detail the 3 stages, 9 steps approach that we talk about, a little bit more detail for those that are students, and we've got time for a few other little bits and pieces and questions, hopefully. So with parenting mediation, it's very well understood throughout the whole system that agreements are always going to be better than orders. When it comes to parenting, if parents can agree about the best way to care for their children after separation, it's going to be better than something that's reluctantly agreed through order. The other principle is that fully informed parents make better decisions. So the work we can do with parents in preparation before the mediation to help them to be prepared is going to be really important. But also the history of family violence and ongoing coercive control strategies can really impact decision-making capacity for parents and our mediations. We've talked in other sessions about risk screening and preparations. We really need to remember that we're still doing ongoing evaluation and assessment throughout the whole process to make sure it's still appropriate. If we think someone's getting pushed along, checking in with them, doing a private session or whatever, to make sure that the process is going to result in an agreement that is actually appropriate for the children involved. So I'm thinking that some of the key things that we're looking at in parenting mediation is trying to rebuild trust. So after separation, trust's usually low. It's usually a barrier to effective communication. If there's been incidents, a really common strategy that people use is they stop talking to each other. So your mediation may be the first time that they've talked in weeks, months. And so we need to always remember that context that we're facilitating this discussion. They weren't having a chat over the breakfast table in the morning. Our job's to create a safe environment where parents can listen to each other. Sometimes that's not possible for them to listen, and we need to use a shuttle process so at least they can negotiate with each other. But where possible, that direct communication can start to rebuild the trust and start to overcome some of whatever the issues are if communication has broken down. We want to try and set the foundations or support the ongoing collaboration of parents working together so that their needs, and most importantly, the needs of the children, are met. But you're not going to get collaboration, you're not going to get parents cooperating unless they feel that in some way their own needs are being met. Sometimes it's easy for us to say, oh, this is all about the children, this is what's important. I would encourage you to, this is what's most important, but also parents that are okay are more likely to mean kids that are okay. We want to really communicate that this is a place for parents to speak up if what's being proposed isn't okay for them. And as always, we need to really be mindful of the vulnerabilities. Sometimes you'll find in mediation that they're sought to be used against parents, whether it's mental health issues, anxiety, depression, or other types of mental health issues, drug or alcohol dependencies, disabilities. These can all be exaggerated, and they're not things that bar people from having children, and they shouldn't be things that bar people from having meaningful contact or meaningful care of their children, as long as those vulnerabilities are not going to impact on the ability to care safely for their children. It's complex, and sometimes there's multiple issues among parents. Probably those of you that work within the government-funded system will see more of these really highly complex, multiple issues, clients coming up where you might be thinking, oh, is there anyone that's really okay for these children? And maybe that brings us on to mandatory reporting and perhaps looking at more creative ways of bringing in extended family and other supports. Yeah, so for me, parenting mediation is about helping the parents to start rebuilding their relationship as co-parents, particularly if it's just after separation, starting to build a working alliance, hopefully, and taking into account all of the vulnerabilities. Anything else that anyone else thinks is absolutely essential that we keep in mind as our goals? And feel free to use the chat if you don't want to speak up. I put this one in because this is one of the models that I use a lot in my thinking about mediation. So what is the negotiation styles that the clients are using? We're usually going to be able to get a pretty good feel for this during the pre-mediation stage. So if they're already naturally collaborating, you probably aren't going to see them at mediation, but that's where we want to get them to be. They may be competing. Often around parenting, there's a lot of competing because it's a finite resource, the amount of time they have with their child. There's only 24 hours in a day. There's only 7 days in a week that we can't change. And so often there's a lot of competition. They're not thinking about the relationship. They're not thinking about the big picture. And so part of what we need to do is try and help people to think a little bit broader, think more about the relationship with the children, the importance of how the time is spent, how all of this impacts the kids. Remind them that they're not a tug of war and all of that sort of thing. Avoiding is also really common to see. Parents that have just been deferring decision making, don't engage or go along but don't commit, renege as soon as they're out of that commitment phase. This is something that when I'm doing a pre-mediation, it's apparent to me that a parent's using a particular style, I'll often talk about this with them and overtly discuss it and the strategies. So I don't know if anyone else is using a different model or models at all with clients, but I think it's helpful. And the same thing, accommodating. So if someone's they're so focused on the relationship with the other parent that they're not actually thinking about what's best for the children or what's okay for them, then that can be something we need to do. Just a note on preparation. It's ideal if parents can get to classes before or online courses like New Ways for Families, or even written material. If you've got the capacity, video material, the court's got a few little videos that are quite good that encourage people to think about not going to court and so on. Think about what your resources are that you're sharing with clients. We've got quite a big resource that probably most clients don't read, but some of them do, because some people get really into research mode when they're separated and they're trying to work out things. We're going to have to rewrite this with the changes coming through, because best interest of the child definition's changing. Shared parental responsibility is a stated thing, and some of the requirements about what people need to consider. If you're working in private practice and you don't have resources like this to provide for clients, think about how you could have. Even some things like Circle of Security or some of those other resources around what basic needs for children. When do we offer parenting mediation? Any time at all? After they separate, when arrangements break down, there's a lot more court-ordered mediations that are happening. If people have got the financial capacity, the courts are ordering people back out to private mediation or back to family relationship centres once they've started court. And of course, reviewing parenting arrangements. Know that a parenting, in most cases, unless the order forbids it, a parenting agreement that's turned into a parenting plan can modify the terms of a parenting order so that we can help them to have their parenting orders grow as the children's needs change or their family situations change. And of course, if there is a family violence order, we must see the order first. There's been a trend with orders not permitting mediation, only allowing communication by lawyers. I'm not sure whether that's just a risk-based approach or if anything was particularly driving that, but it's a trend I've seen pretty much around the country. I don't know if others have as well. But you must not just take the client's word about it, you must get the copy of the order. Otherwise, you're enabling a breach of the order if you bring people together. This is the process that we tend to use. So it's basically, we're looking at it as 3 stages. So the first stage is creating the environment for the negotiation. The next one is increasing understanding and exploring options. And then the final stage is agreeing on solutions or making decisions or working out what the next step. I've set up to go through in a little bit more detail some of these, but I'll just do a bit of an overview. Now, some of you here might be using slightly different processes. Some might have learned the basic mediation process with the diamond model that Resolution Institute teaches, with FATA in the middle in this exploration phase. And it should be that this is not equal distribution of time. The middle bit needs to be the fattest bit. And look, please feel free if you've got any questions or comments as we go through here. But generally, we'd always be wanting to see mediators' opening statements. So we're starting the process off, setting the framework. In facilitative mediation, which parenting mediation is, we own the process and the parties own the content. It's really important that we set up what the process is going to be. Then we move on to the parties' opening statements. This is really about working out what they've come on this day to try and resolve. It may change from what was discussed in the pre-mediation. Sometimes they've had some further information or advice, so what they were going to focus on might have changed. They may have decided that something that they talked a lot about in the pre-mediation they're not going to raise now. So we can't really have the agenda pre-formed before the mediation day. There are some models, I think, where that does happen and maybe it's just checked in. But I do see some benefit in allowing this time for the parties to speak about what the key issues are. And of course, in your pre-mediation, if this is your model, then you've had to prepare the clients and tell them that this is what's going to be expected of them, and understand that this is probably something really scary for them when you say that. Oh, and then there's going to be opening statements and you're going to talk for a few minutes about the key things that you'd like to resolve. So be mindful that we need to prepare, and I'll go into a little bit more detail about that in a moment. The agenda for the session, so we want this to be neutral and mutual. The process that we recommend and encourage is that you don't have this person's agenda item and that person's agenda item. You use your skills to manage the information that you've shared to work out how you can phrase them in mutual terms. And again, we'll talk a little bit more. And we get the parties to negotiate the order so that there's a few benefits again. The next step, once we've got the agenda, we move on to exploration. This is really where we're wanting to get the parties to speak directly. This is not for shuttle. Or in shuttle, we'd use a slightly modified process, and there's a lot more of us collecting, digesting, confirming and transmitting information back and forward. But in this, we want to facilitate direct communication. The first stage is we're really trying to facilitate understanding. Almost inevitably, when people are in conflict, they are suspicious of the other party, and they're usually going to interpret negatively things that might be quite neutral or even intended to be positive. So it's really an opportunity to try and clear up some of those misunderstandings, and where possible to encourage acknowledgement. It really makes a big difference if someone says, "You're a great dad, but we've got to sort these things out," or "You're a fantastic mum, and I know the kids need to have a lot of time with you, but I'm really hurting not seeing them." If people feel comfortable to say those sorts of things, it can really make a big difference to the next step of option generation. So once the agenda item is understood, then it's really starting to work on what are the options. And this more choice is better than less choice, because if the first thing that comes out, you jump on it and pounce on it and try, okay, we've got an agreement already, fantastic. It might be at the expense of a better idea. And humans automatically, once we start having choices, we automatically start creating criteria to work out which one's better. And that's a really beneficial process as well, because that brings out more sharing of what the people think is important, if that makes sense. Now, in this model, it's not as clean cut as this. So exploration and option generation, we don't want to start doing too many options until we're relatively confident that people have got a shared understanding. And private sessions may need to happen earlier. We definitely want to have a check-in session before they really get stuck into negotiation, just to make sure that someone's not actually avoidant and just being swept along and looking like they're agreeing and they're not at all. Or if someone's really stuck, to help try and understand what's going on. Those private sessions, they're confidential within the confidentiality of the mediation. They give us a chance to, if necessary, if someone's stuck, we might need to talk about whatness and batness. So what's the worst alternative to negotiated agreements? If you don't come to an agreement today, what might happen, or what's a better alternative? So getting those parameters can help people unstick. And sometimes they might need a bit of help with developing proposals. So they may feel it difficult to raise something, and those private sessions give us a chance to coach a little bit how they may, talk about something. What do you think you might say? And do you want to practice? Do you want to say it to me? And I'll try and be them. And it's okay to do that sort of thing in a private session, just to give people the confidence to speak up if that's an issue. After that, then we're really wanting to try and move into getting hopefully some agreement on things. And if during that option generation stage things had come up and the other one said, "Yeah, I think that's a great idea, you make a note," but you're not locking, okay, that's an agreement. You say, okay, I'll make a note of that, and we can come back and explore that a bit more later. So this is where you might bring back, now, before you said blah, 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 what are your thoughts about that? Is that still something you want to move forward with? Devil's advocate, so really looking at reality testing. What could go wrong? What are the barriers? What if you turn up late? If the changeover is at school, and if someone's driving an hour to get there, what if you're late? Oh, I won't be late. Okay. What if you were? Those reality testing sort of questions. My thinking is, if we can break the agreement just through our words in the mediation, it really wasn't a good agreement. We need to treat them robustly enough that we know that it's got some substance. It's an agreement that's broken as soon as you finish the mediation isn't really that valuable. And then the documentation. So we want to write up the words of points of agreement in their language. So how do you want this written? Just throw it out there, and then you be quiet. So this is one of our mediator skills, is silence. Someone with less fortitude than you will fill that silence. Always, I can guarantee you. Test it. You put a question out there and you just wait, someone will come in. If one person wants to dictate everything, every single clause, you ask the other person, is that Do you agree? Does that make sense? Is that how you want it worded as well? So don't fall in the trap of being dictated to by one of the parties, because often one's going to be more articulate, more wordy, more something, or more keen to dominate. And so we want to not fall into that trap and be dictated to by one person. Write up action steps. So who's going to do what, how, when. We're not really putting the why in. The why should have been discussed before, but we're going to talk about who's going to do what and when, and the what ifs. So that might be, and then close, depending on what stage. Like if they're just doing a review of an existing agreement, you may have things finished in one session. If they're wanting to go towards parenting orders, it's probably going to be a lot more. There might be another session needed, or a review session. So if the trust is very low, a review session is a really good strategy to have in place. Having a scheduled date, it tends to keep people honest, because if they know they're going to be caught out if they're just saying they're going to do something and they're not doing it, and they know it's not the consequences of getting caught that tends to influence behaviour as much as the likelihood. And then, of course, the practicalities. We need to confirm how we're going to get that information back out to people and so on. So any other thoughts? Does anyone do things radically differently to this, or? And sometimes our clients take positions, but with our reality testing, with the exploration, we can try and find what's the interest below that. Like, why is it important? People will go really strongly for their interests, what really matters to them, but they often don't feel it's safe enough to talk about it. And so, you've got this, they're really being strong about this, but they won't tell me. And that's our skills to get in underneath it, as Cynthia says, to find out what that real reason is. Mary, yes.
I was just wondering then, what would happen if the person actually doesn't know themselves?
Sometimes that's the case. Hopefully you've been able to explore some of this more in the pre-mediations. These things might not be as much as a surprise when you get to the mediation, and sometimes you don't get to do it. But private sessions, sometimes we can take them through a bit of a process to uncover. We don't always have that opportunity, but yeah.
Absolutely, the private sessions. And I usually bring up the one is, there seems like you're attaching a lot of significance to this. Are you willing to share why? And that's with a one-on-one with them.
Yeah.
Because that's what it is. From what you're saying, Cheryl, there's a lot of significance being attached to separating the children. And if you can unpack, that's a good one.
Yeah, absolutely. Yeah, it may not be as much about the school as about not wanting them together for some unknown purpose. But yeah, there's always a purpose. And as convoluted as it may seem, in that person's mind, there's always a positive benefit of whatever it is that they're trying to advocate, even though from our value system, we may not see it as positive. And we need to step into their world briefly to try and understand. And that's around not projecting judgment, because if we're evaluating from our world, our point of view, then it may be, even though we have to use judgment to make sure that things are safe and that it's appropriate. So yeah, there's a range, and then there's outside the range. So we've got that.
And that's where it was difficult, because he was very dominant and I had to really settle him down a lot.
Yeah.
There's a real imbalance of power here. And that was the whole reason they came to mediation on just that.
Yeah.
In the pre, it was just, they had done mediation prior, but this is a sticking issue, and they were doing mediation. So yeah, I'd go borderline quite aggressive. I was actually, and I was, all that was coming through my head too, because I was new, thinking, I actually don't think this is appropriate. Like at the moment, this is a real power imbalance here. He's just she was really upset. And anyway, that's for another time.
And it's like this competing and avoiding type thing, or of competing and accommodating. So she wants to keep peace. Okay, fine.
Yeah.
And do my child to the school I don't really want to, because I just can't handle this battle anymore. And for him, he wants to win on this point.
Yeah.
But there's
I might
always
take it to supervision.
yeah.
Thanks, everyone. Sorry to interrupt there.
No, it's useful because it just reminds us we've got a whole lot of tools that we can use, and it's honing our confidence with them, knowing which one to try. And I say try deliberately because it doesn't always work. Like, it doesn't matter how experienced you are, you'll try something and sometimes it just doesn't work. And
It's sort of about building the language, isn't it?
yeah, absolutely. Yeah. And I was just planning to go through the first 3 steps around that. So mediators opening statements, why do we do it? I see there's quite a few benefits. Usually clients are quite nervous and unsure. And so having this quite boring bit at the start, it's actually calming. As long as it's not too long. If it goes too long, then they start getting really agitated. It just brings everyone back to the present of what we're here for, process, practicalities, what happens if you're on Zoom, what happens if you drop out, whatever. Establishing the use of names. This is really actually quite important to make sure that people are using each other's names. Depending on the culture, sometimes people want more formality. I've had a few where they wanted to be called Mr. and very, very few, but it can happen. But you don't want pet names and things like that because that can be really quite triggering for people. Ground rules, and I say if needed, not everyone uses ground rules as a formal thing at the start of the mediation. It may be just your framing up in your housekeeping of it's really important we take turns to speak, and I will stop if I feel like people are not listening and talking over. Or in your pre-mediation, if you've worked out that someone really does run riot over the other, they do it to you in the pre-mediation, you may decide you want to have ground rules, and it's be really firm about it and be really strict about enforcing them to make sure that you're in control of the process. And then best interest of the child, it's jargon. Like, parents don't understand what the court means by best interest of the child. So it's really quite important that we clarify that for them. And as hopefully everyone knows by now, the definition is changing. And so that needs to change in the way we talk about it. But the best interest of the child, according to the family court, isn't mother knows best or father knows best. It's for the child at the moment to have a meaningful relationship with both parents as long as it's safe to do. And then in the future, it's going to be safety, the wishes of the child, the relationships, the other things that are important to their physical, emotional, psychological well-being, and so on. Making sure of that. How do we do it? In practice, you might use your agreement to mediate headings and just go through. You may have a checklist, you may have it memorized. Introductions, best interest of the child, housekeeping. This is the list from the script that we provide in training. Agreement to mediate confirmation, that's there. Confidentiality, inadmissibility. Confidentiality is really important, and inadmissibility, so that people know until you reach an agreement about what you're discussing. And if you decide that you want to sign and date it, it isn't able to be used as evidence if you do end up in court. And ideally tell people the benefits of that. That means you're able to freely negotiate, come up with ideas, check them out, see if you think they work. And then if you're confident with them, then you can commit to them. All of that, but keep it brief. Check in with the clients. Do they need more detail? If not, don't give it. And get agreement on the critical things around behaviour and names and what have you. Parties opening statements. I think this is a really important part of the mediation because it gives us the chance to demonstrate active listening, a little bit of modelling for them, and also to find out what they think is important for them to discuss today. So ask them in turn, demonstrate active listening. So show them how to listen respectfully, ask relevant questions to what they've said, use your summaries to confirm your understanding, show them how that's done, build rapport. So this is a chance for them to feel heard, and be really firm but gentle about enforcing your ground rules. So don't come off as a cranky school teacher because you're going to struggle with before. I'm sure you weren't a cranky school teacher, Wendy. But yeah, we want to gentle and up the ante as far as we need to go until they behave. So what do? Facilitate the parties deciding who's going first. So we can use these things for multiple purposes. So we get to see how they negotiate. Who wants to go first? Doesn't matter. I'll go first. Okay, is that all right with you if they go first? Yep, fine. You've just had a little negotiation. And then focus them. Can you briefly tell me about the issues you'd like to resolve in the mediation today, or something to that effect? 2 or 3 clarifying questions. We're not going to do the inquisition. We're not going to ask about other people's motives. We're not going to reframe. We're not going to try and get into solutions. But we might want to know about outcomes. What are they trying to resolve? Where the children are going to go to school. Not that they're going to go to this school. One of the things that they want to work out is where the school's going to be. The process that I think works well is doing little mini summaries as you go along. So do a little mini summary to determine that you've got that agenda item worked out, and then move on and cycle through. And is there anything else that's important today? Couple of questions, mini summary, thank the client, and then repeat with the other. There are some other methods where both people speak and then they do a joint summary. I think it just takes up too much processing power to keep track of all of that. So I go through the easier process of do one, finish it, do the next one, finish it, and then move on to your agenda. Whatever works, but just be consistent. Make sure you do both with both parties. Don't shortchange the second one by not doing an overall summary or doing things different. Ask the parties to talk to you. So this is not about them sharing to each other. Sometimes they'll try to do that. Can you tell me? Direct them with your language. Keep it brief. We just want to get out the key issues, nothing more than that. We don't want to waste a lot of our direct conversation time on this. Keep it structured. Don't go back to the other party once one party's concluded. The whole thing can fall apart and you just end up with a big mess. And remember to keep your language unbiased. After we're going to use recorded speech. We're not going to use their language that's going to trigger people, making it sound like we've accepted someone's description of the event. And don't try and transcribe what they're saying. Your purpose in anything you write is just to highlight the agenda items. And the easiest way to do this is have one piece of paper, divide it down the middle. The first person to speak's name on one side, you just write down the key things in 1 or 2 words. Other one, here's your agenda items. And your little summary is really testing out the key issues ready for your agenda. And this is the only other one I'm going to go through in big detail today. And the next step, forming the agenda. This is the guiding structure for our mediation. If you don't have an agenda, you've got no way to redirect people if they start going around in circles. You might end up looking like a counselling session, not mediation. We want to keep it focused towards achieving outcomes for things that are issues for this family's care of their children. So it ensures the key issues are recognised, provides the opportunity to talk about interests rather than positions through the way that we mutualise the agenda points, and it's outcome focused rather than describing the problem. We want outcomes, not solutions. Outcome is what school they go to. Solution is they go to the Catholic school. So if you think about levels of abstraction of how concrete or abstract, we want to go up a little bit so that the terms we're using are a little bit more abstract. So there's a number of different ways. For example, vehicle is an abstract, whereas a Prius or a Triton concrete, their type of car. So we want to go up abstract enough that it could be any vehicle that gets there. It could be a train that gets them there. Does that make sense? Probably not a good example, but anyway. Yeah, so a lot of what we do in mediation is moving to more abstract to less abstract. So when people are at loggerheads, we want to go to more abstract because it's more general and it's less objectionable. And then we need to move back down into more detail to actually get the specificity that we need for an agreement. I really don't like agendas where agenda items are ascribed to one parent or another. We can always find a way to put them into mutual language by chunking up a little bit. So briefly describe each agenda item in terms of relevance to both parties. Check in with them that they're comfortable with the wording, they understand it, but describe it first. Don't just write your list and put it up on the screens. If you need, learn to practice to do two things at once, talk and write. If you need to dot points not numbered, we're going to again use the agenda as a chance to see how these people negotiate. Keep the number of items manageable. So 10 items is just not going to be possible in a mediation session. For example, spending time arrangements, how we communicate about the children, special days and holidays, agreement regarding health concerns. It might be the second person's just gone on and on about there's concerns about the children's health and they're not feeding them the right food. The other one hasn't said anything. However, I'd probably say something. It sounds like there's some issues around the concerns with the children's health. I'm going to put that on the agenda because it's an important thing. If that is something of an issue, do you both agree that's something that needs to be discussed? Generally, they'll agree. If one doesn't, then I'm going to have a little negotiation around that agenda item, but I'm still not going to say this is Party B feels that this needs to be discussed. It's going to be me that feels it needs to be discussed based on what they've discussed. We want to get them to negotiate the order without us putting forward an evaluation system. So don't ever ask which one's most important, because now you've just created a chance for someone to win and someone to lose. Which do you want to talk about first doesn't put the criteria of being important. Sometimes people might want to deal with the easiest one first. And if you say which is most important, you've created criteria that might not be what's going to work for them. Notice how they negotiate and make it brief. Manage the negotiation. Doesn't really matter which is discussed first. Which one will it be? Silence. Let them work it out. If they can't work out which of 2 points to talk about first, so they're not going to be able to work out where the child sleeps every night. Yeah. So as I said, I'm not going to go into more detail about those ones because we don't have time. If you're on the course, there's some scripts that you're able to use. Please modify them, update them for your language. And these are training wheels, like on a bike when you started out. You only use them as much as you need them, then lift them up, then go to a dot point list and use that for a while, and then eventually you won't need it. The mediation and communication skills manuals in there that goes into lots and lots of detail as well, and that's available for members. The assessment tool for the FDR course goes into lots and lots of detail about each step in the process, but overall, what's needed to be competent is we have to determine and respond to family law requirements. We've got to apply our ethical standards to the process, informing participants about their rights and responsibilities, so on. We need to use our facilitation skills. Practice the facilitation skills everywhere you go. Practice them on the person at the supermarket. Practice them with your family until they tell you to stop, and then do it some more. When the children are arguing with each other, and now, Jonathan, what did you hear Sue Ellen say there? These are skills, you need to keep them sharp. They're tools, and you need to really get a nice, deep understanding of when to use them and how to use them. We want to assist the participants to generate and evaluate options, encourage mutual personal understanding, maintain our impartiality. Neutrality is a word that's often used in mediation. It's hard because we aren't actually neutral. Like if we were completely neutral, we wouldn't change the situation. So in some ways, it's better to think of it as impartial. We don't have a favourite. We're not on anyone's side. We're on the side of both of them. Maybe we're on the side of the children if we're on anyone's side. But I see us as a catalyst for change, to change the direction that they've been going to one that's more productive, more collaborative and cooperative, we hope. But we definitely need to be impartial. We can't be taking sides. And we need to, if there are agreements reached, we need to give them that in writing so that they remember, because it's quite an overwhelming experience, the mediation. And so they do need that reminder. I'm talking about facilitative mediation. There are other styles, and we can go into more detail with these. Transformatives up the other end of the spectrum, where it's much more about the relationship between the parents and less focused on the agreement. Legally assisted can be very helpful, and in times, particularly with higher conflict people, probably used more in the financial realm, but it can be relevant as well with parenting. Child inclusive, where we're using a child specialist to meet with the child and then come in and share their insights into the mediation. Child informed, we can have a specialist come in who hasn't met the child but's able to provide some child developmental related information. Family group conferencing is something that's just starting to be explored as a way of bringing in the wider family into the mediation process rather than just mum and dad, which is particularly relevant for families that aren't nuclear families, because shock horror, not all families are organised that way, and evaluative. So that's getting more towards the conciliation, not as much used for parenting, but the court one can be a little bit more that way, where a registrar might do the mediation and give their opinion on some of the things that people are looking at. Arbitration, which is like a private judge, really not being used for parenting, but can be for property. And there's a lawyer-led process with some general legal advice, which is getting right up at that end of the spectrum as well. With parenting, though, it's very imprecise in terms of the legal advice. You can't plug in a family and come out with this is what the arrangements need to be. It just doesn't work that way. Oh, that's just the assessment tasks for anyone who's on the course. Just a quick overview of the types of agreements. Many families just work without any type of formal written agreement, or they just use text messages about what's going on. A written agreement, again, if it's a written agreement but it's not been signed, it can't be used as evidence. There's no evidence that the other person's agreed. If it's written, signed and dated, then it's a parenting plan, and that must be considered by the court if they end up in court and how much they've actually complied with that. But how the court considers is up to the particular registrar or judge, binding on the court. But as I mentioned before, it can vary the terms of a court order with a written parenting plan if the court order doesn't specifically prohibit that. Consent orders, if they reach an agreement in mediation, there's a process that they can apply for consent orders, which isn't just sending in the agreement. Some parents misunderstand. It needs to be drafted into orders on the proper form, and there's an application process. There is a do-it-yourself process, but most people find that the drafting needs to be done by a lawyer for the court to be happy with it. It's not impossible, but it's harder. But it's just fee-for-service legal services rather than a full expensive case. And then if people can't reach agreement, then if they've come to mediation, we'd be asked to issue a Section 60I certificate, and they'll need to go to court. Again, much fewer cases than previously are now going to court for orders. A lot of, into the 80% of cases now are being dealt with outside of court, according to Senior Judicial Registrar Anne-Marie Rice in her presentation last month. Most things are being dealt with at this end of the spectrum, and very few are going to the court. That's what I had planned. The mediator network, there's opportunities there to have discussions and other communication. The Family Mediators FDRP's Facebook group if you're not a member of that group, it is a good group with lots of chatter to be part of. People put up scenarios and various things that are happening. I'm one of the moderators, and it's always a battle to keep it nice because it's on Facebook, but it's mostly nice. It's only for DRP or students. It's not a general open group. And yes, that's all. There's example documents and resources in the members and students course. If you go there and look for the FDR kit, you'll be able to find some resources there that you're able to use as well. Oh, look at you, Rowena, how good you are. Any final questions or comments? I know that was a lot of blah, 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 blah information at you, and I might just stop the recording.